Have you ever wondered how a company adapts its foundational rules as it grows and changes? Every business evolves, and with that evolution often comes the need to update its internal operational guidelines. But how do those critical governing documents themselves dictate their own modification? Corporate bylaws specify amendments by outlining a precise, structured process that must be followed to alter, add, or repeal any of their provisions. These bylaws serve as the internal rulebook for a corporation, detailing everything from meeting procedures to officer duties, and critically, they contain the very instructions for how they can be changed. This typically involves specific notice requirements, designated approval bodies like the board of directors or shareholders, and defined voting thresholds. The reason for these detailed amendment procedures lies at the heart of sound corporate governance. By establishing a clear, formal path for modifications, bylaws protect the corporation from impulsive or unauthorized changes. They ensure stability, provide predictability for all stakeholders, and safeguard the interests of shareholders by requiring proper deliberation and consent before fundamental rules are altered. This framework prevents a small faction from unilaterally changing the company's operational structure, thereby promoting fairness and transparency. Practically speaking, the process for amending corporate bylaws usually begins with a proposal from an authorized individual or committee. This is followed by a formal written notice, delivered to all relevant parties such as directors or shareholders, which details the proposed changes and the date of the meeting where they will be considered. During this meeting, the proposed amendment is discussed, and a vote is taken. The bylaws will dictate the required vote, which could be a simple majority of those present, a majority of all outstanding shares, or often a supermajority like 2/3 or 3/4, especially for significant changes. Once approved, the amendment is formally recorded and incorporated into the corporate records. It is also important to recognize that bylaws, while fundamental, are generally more flexible to amend than a company's articles of incorporation. The articles are the public document filed with the state to create the corporation, while bylaws are internal. Consequently, bylaws often permit amendment by the board of directors, sometimes even without direct shareholder vote, provided the bylaws grant the board such authority. However, articles of incorporation almost always requiring a shareholder vote for amendment due to their foundational legal nature. Understanding and meticulously following these amendment provisions ensures your corporation remains legally compliant and operates smoothly through any necessary structural changes. It empowers the company to adapt effectively while upholding the principles of good governance, protecting all stakeholders, and maintaining the integrity of its internal operational framework.